Mandatory training of new FINTRAC obligations for mortgage brokers. This training will last approximately 20 minutes. Implementation of new FINTRAC obligations for mortgage brokers. Effective October 11th, 2024, all mortgage originators, administrators, and lenders across Canada must adhere to requirements under the PCMLTFA and its associated regulations. You can find more information on the website for the Financial Transactions and Reports Analysis Center. Mortgage agents and brokers licensed with Rateshop are required to review the requirements under PCMLTFA to ensure they understand the scope and application of the federal requirements. If you are ever unsure, contact your anti-money laundering officer for the brokerage. All mortgage originators, administrators, and lenders nationwide will be required to collect, enforce, and report to the Anti-Money Laundering and Anti-Terrorist Financing Compliance Program. The compliance program must ensure that all due diligence, record-keeping, and reporting obligations are met. In this training you will cover 1. Adherence to the FINTRAC compliance program. 2. What you need to report. 3. How to manage record keeping. 4. What are the administrative penalties? Customer identification. 1. Valid identification. Ensure you obtain and verify valid identification documents. Example, passport, driver's license. 2. Beneficial ownership. Identify individuals who own or control 25% or more of a corporation or entity. 3. PEP. Politically exposed persons. Identify if the client is a PEP or HIO, head of an international organization. Conversations. 1. Source of funds. Ask clients about the source of their funds and document their responses. 2. Purpose of transaction. Understand and document the purpose of the transaction and ensure it aligns with the client's profile. 3. Clarifying inconsistencies. Address any inconsistencies or red flags that arise during conversations and document how they were resolved. Record keeping. Client information. Maintain accurate records of client information, including names, addresses, dates of birth, and identification documents. Always upload every document received into FinMo, so all docs are traceable for further review. You can find evidential trail of money laundering in these documents. A. Bank statements. B. Down payment proof. C. Cash deposit receipts. D. Mattress money deposits. E. Large incoming and outgoing wire transfers. F. Sale of property outside Canada documents. Transaction records. Keep detailed records of all transactions, including amounts, dates, and parties involved. Request the use of funds on equity takeouts and document the use in CRM. Any transactions greater than $10,000 require backup and source, otherwise to be escalated to Camlo at Rateshop. CA. Any payouts over $10,000 for bill payments, debt, mortgage discharge, or loans to be documented in your CRM and saved in FinMo under Camlo document tag. All your ready-to-fund deals should have on file as a part of your brokerage compliance package the following documents reviewed, signed, and date to pass compliance deal stage. A complete KYC, PEP, and HILS disclosure. Proof of any deposits of $10,000 or more into the checking, saving, investments accounts or for bill payments / debt / mortgage discharge or loans to be documented in your CRM and saved in FinMo under Camlo document tag. If there is any suspicion on these, please report immediately to Camlo at Rateshop. CA. Suspicious transaction. 1. Unusual transactions. Look for transactions that are unusual based on the client's profile. Example, large cash deposits, frequent international wire transfers. 2. Incomplete information. Be wary of clients who are reluctant to provide complete information or who provide inconsistent information. 3. Third-party payments. Be cautious of transactions where funds come from or go to unknown third parties. What is a suspicious transaction report? A suspicious transaction report is a type of report that you must submit to FINTRAC when a financial transaction occurs, or is attempted, in the course of your activities and there are reasonable grounds to suspect that the transaction is related to the commission or the attempted commission of a money laundering or terrorist activity financing offense. You are not allowed to inform anyone, including the client, of the contents of a suspicious transaction report, or that you have made or will make such a report, if the intent is to prejudice a criminal investigation. This applies whether such an investigation has begun or not. It is important to not tip off your client about the fact that you are filing a suspicious transaction report. Therefore, you should not be requesting information that you would not normally request during a transaction if you believe this would tip off the client. What are reasonable grounds to suspect? Reasonable grounds to suspect is the required threshold to submit a suspicious transaction report to FINTRAC and is a step above simple suspicion, meaning that there is a possibility that a money laundering or terrorist activity financing offense has occurred. You do not have to verify the facts, context, or money laundering or terrorist activity financing indicators that led to your suspicion, nor do you have to prove that a money laundering or terrorist activity financing offense has occurred in order to reach this threshold. Your suspicion must be reasonable and therefore not biased or prejudiced. Reaching this threshold means that you considered 1. The facts, 2. The context, 3. The money laundering or terrorist activity financing indicators related to a financial transaction. After having reviewed this information, you concluded that there are reasonable grounds to suspect that this particular financial transaction is related to the commission of a money laundering or terrorist activity financing offense. It also means that you are able to demonstrate and articulate your suspicion of money laundering or terrorist activity financing in such a way that another individual with similar knowledge, experience, or training would likely reach the same conclusion based on a review of the same information. Many factors will support your assessment and conclusion that a money laundering or terrorist activity financing offense has possibly occurred. These factors, along with an explanation of your assessment, should be included in the narrative section of the suspicious transaction report, specifically the details of suspicion section. The reasonable grounds to suspect threshold may be better understood when you have an understanding of other thresholds. 1. Simple suspicion. 2. Reasonable grounds to believe. Simple suspicion is a lower threshold than reasonable grounds to suspect and is synonymous with a gut feeling or hunch. In other words, simple suspicion means that you have a feeling that something is unusual or suspicious, but do not have any facts, context, or money laundering or terrorist activity financing indicators to support that feeling or to reasonably conclude that a money laundering or terrorist activity financing offense has occurred. Simple suspicion could prompt you to assess related transactions to see if there is any additional information that would support or confirm your suspicion. Reasonable grounds to believe is a higher threshold than reasonable grounds to suspect and is beyond what is required to submit a suspicious transaction report. Reasonable grounds to believe means that there are verified facts that support the probability that a money laundering or terrorist activity financing offense has occurred. In other words, there is enough evidence to support a reasonable and trained person to believe, not just suspect, that a money laundering or terrorist activity financing offense has occurred. For example, law enforcement must reach reasonable grounds to believe that criminal activity has occurred before they can obtain judicial authorizations, such as a production order. Risk assessment. High-risk clients. Identify clients who pose a higher risk of money laundering or terrorist financing. Example, clients from high-risk countries, clients with complex ownership structures. Enhanced due diligence. Apply enhanced measures for high-risk clients, such as obtaining additional information or monitoring transactions more closely. Reporting. 1. Large cash transactions. Report cash transactions of $10,000 or more to FINTRAC. 2. Suspicious transaction reports. STRs. Submit an STR to FINTRAC if you detect any transaction that may be related to money laundering or terrorist financing. 3. Terrorist property reports. Report property owned or controlled by or on behalf of a terrorist or terrorist group. 4. Filing a report. Once you have determined that the suspicious transaction is indeed to your knowledge a flag, you can submit one of the applicable reports found on the FINTRAC website under paper reporting forms. By diligently monitoring these aspects, you can help ensure compliance with FINTRAC regulations and contribute to the prevention of money laundering and terrorist financing in Canada. Administrative penalties. A. To ensure compliance with PCMLTFA legislation, FINTRAC is authorized to conduct compliance examinations to assess whether registrants are meeting their requirements under the law. B. FINTRAC has the authority to issue administrative monetary penalties to reporting entities for noncompliance. Penalties are categorized based on the seriousness of the violation and the entity's compliance history, ranging from minor to very serious infractions. 1. Minor violation, $1 to $1,000 per violation. 2. Serious violation, $1 to $100,000 per violation. 3. Very serious violation, $1 to $100,000 per violation for an individual and from $1 to $500,000 per violation